We're ready to go. I'll call this study session to order. Can we have a roll call, please?
Mayor Scott Anderson.
Here.
Vice Mayor Bobby Buckley.
Here.
Councilmember Kenny Buckland.
Here.
Councilmember Monty Lyons. Here. Councilmember Chuck Bongiovanni.
I am here.
Councilmember Young Kaprowski. Here. A quorum is present.
Thank you.
Councilmember Jim Torgerson. A quorum is present.
Much to your chagrin.
What? I didn't hear you.
I didn't hear you. We have one item on the agenda tonight, presentation and discussion on public records requests related to cost, process limitations, and allowable options by statute. Chevelle?
Thank you. Good evening, Mayor, members of council. Chevelle Herrera, Town Clerk. I'm here this evening with our Town Attorney, Chris Payne. We will be discussing public records requests. This item came before us at the request of council. So the intent in this presentation will to provide an overview of public records for the Town of Gilbert, talk a little bit about the data that we're seeing, specifically numbers of requests, completion times, costs associated with public records requests, some fees that we are able to charge, and then kind of end that presentation talking about some limitations and restrictions under public record law. And of course, if you have questions between the presentation, please interrupt and we'll be happy to discuss anything further. So this first slide, I wanted to provide a little bit more of clarification as we move into this conversation. The first bullet point there, it talks about Arizona Public Record Law versus the Freedom of Information Act. Just more of a distinction is we often hear the term FOIA being used, but Arizona actually is governed by Arizona Public Record Law, whereas FOIA is for federal agencies. So although there are some provisions that I'm sure are similar, I just wanted to make that point of clarification into this discussion that Gilbert falls under Arizona Public Record Law specifically. The second bullet point just talks about some of the titles in statute that we refer back to. So when we do talk about law or statute, we look towards Title 39 in the Arizona Revised Statutes related to public records, and Title 41, which is specific to records management. And then the third bullet point there, we are not going to go into any level of detail regarding subpoenas. I just wanted you to have awareness that those are also types of records requests that we provide. We don't get a lot of them, but we do get a handful of them, and they are court-required document production. Sometimes that comes with a requirement of testimony as well. So when we do get those, we have to make an internal decision how to prioritize those. But the majority of requests that we get and what we'll be talking about today are public records request specific. The fourth point is just we must comply with retention for all of our records here at the Town of Gilbert and other municipalities. For records related to records requests, the state does require we keep those for a year. We do keep those for 2.5 years. So I just wanted to make that point of clarification too, that while the system is purging those at the end of 2.5 years, we are meeting that requirement at the state level as well. And then the fifth bullet point here, Chris may want to go into a little bit more detail, but access to records may be outweighed by confidentiality, privacy interests, or the best interests of the town. So if there's a request that we feel might fall under any of those, we will look for our town attorney's decision on whether or not any records fall under those categories and are subject to not being disclosed. Did anyone have questions on that Chris could speak to, or?
I have a question. Best interests of the town? Can you clarify that?
Yes, Mayor Anderson, Councilmember Torgerson, Town Council. So these are the exceptions to the public records law, right? Confidentiality, that's pretty easy. Things like the attorney-client privilege, we don't provide that information. Privacy interests, think of HIPAA, PII, personally identifiable information, will not disclose some stuff, or sometimes we'll redact it. And then the best interest of the town, that's an argument. It's created in case law where the town can refuse to provide documents when it's in our best interests. And one example of that is one of the court cases, one of the seminal court cases, Arizona Supreme Court cases on this is someone had made a request, this is going back in the early 90s, for ASU was hiring a new president. And the media had requested, I want a copy of all applicants for that position. And Arizona State University pushed back and said, no, we're not going to provide that to you because a lot of these people, they're not going to be considered and they have current jobs, and we think it will harm the university if everyone that applies for a position there like this knows that their name's going to be out there because it could impact their current employment. And we'll provide you the finalists once the finalists are there, but not everybody. And that ended up, they got challenged on that, ended up in the Supreme Court, and the Supreme Court said, hey, a city, a state, under the public records law, the county, they can withhold documents if they can articulate that it's in their best interest to do so. So you have to articulate a business reason why it's not in our interest to do so. So one example, besides something like that, one example that we would do is we could say if someone's making a super broad request and we do say they want every email ever sent for the past 5 years from anyone associated with the town, we'll do a record search. IT will run the number. It's probably millions of records. And we're going to come back and we're going to say, well, you know what? We're not going to fulfill that because that will take 5 years of 18 full-time staff members to review each document. So the way we would not respond, we'd say it's in our best interest not to provide that because it's going to take our employees away from their other jobs to provide, to respond to this very, very broad request.
But doesn't that also, wouldn't that, when, I'm just looking at the actual words, in your best interest. If the town per se did something wrong, would it be in the best interest of the town to reveal that through a records request? Probably not in our best interest, but I don't think we have coverage.
Correct. No. The law says, and the case law says, that the town has to articulate the reasons why it's not responding to that request, why it's refusing to respond. And because it could make somebody at the town look bad or make the town look bad, that's not an appropriate reason, and the town could not, under the law, withhold any records for that reason. It's related to the business purposes. If someone wants, for example, if the town's negotiating a development agreement with a party and somebody wants all those negotiations, we're going to say, no, we're not going to provide the negotiations because the agreement's not yet finalized, and understanding or knowing what the town council's position is and these negotiated points is going to harm the town because we're in active negotiations. That's an example of when it's in our best interest. But just because it can make someone look bad, that absolutely is not. We would provide those documents.
Thank you.
All right, diving into a little bit more specifics on public, sorry, go ahead, Councilmember Bongiovanni.
Thank you. Chris, in your example of the press trying to get information from ASU, what would be the process if ASU said, no, you have to give me that information? What would be their process, their next step?
So Councilmember Bongiovanni, you're talking about the press in
Whoever.
that scenario?
Let's say you deny someone FOIA information. What is their process after that?
So under the public records law, we're required to promptly respond, and Chiavelli will get into that in a bit. If we come back and we say we're not going to provide these documents because they're subject to one of the exceptions, right? The town's best interest, and if we're pushing back on that scenario, we have to provide and articulate a reason why. We can't just say it's in our best interest. We have to tell them why we're not providing it. Or if it's confidential or it's subject to privacy interest, we have to tell them we're not providing these documents for this reason. The next step for the requester in the ASU case, the media, would be they have to file a public records lawsuit. They have to go to court, and in that scenario, the burden shifts on the city, right? If we're not providing documents and we get into court on a public records lawsuit, the plaintiff typically has the burden, in this case, the person making the request, but in this scenario, it would be us to provide, we carry the burden to the city or to the court to explain to the court why these documents are confidential or why they're not going to be released in our best interest. And again, the courts are they give deference to the public records law, their open meeting law, or the public records law are what they are. And so for us to refuse to provide documents, we have to have a solid good faith basis. Because the courts will provide, they'll order you provide. So we take that very seriously here. So if we are responding to a records request and not providing documents, it's because we've analyzed it and we know we have a good faith basis to do so.
Thank you.
All right, I'll move right into public record law specifics. So under the Title 39 Public Record Law, it does require that public records and other matters in the custody of the public body be promptly furnished, as Chris just spoke to, and made available for inspection. It does require a distinction between commercial and non-commercial requests. So that is one of the first things requesters must identify when they submit a request, is whether or not they are going to be using it for a commercial purpose or non-commercial. And for clarification, a commercial purpose means in obtaining the records, the requester intends to sell or resell them, and they anticipate some type of monetary gain. They have to be upfront and forward with that information at the time of the request. Most of our requests are non-commercial, and so we do process them as that going forward. Public record law does not require the creation of new requests to fulfill a request, so we do get requests sometimes that asks for very specific record types or details. We provide records if they're available in the format in which they're available. We are not required to recreate any type of record for several reasons, but mainly because that's not a record we currently keep, and in doing so, we are now creating new record series that we have to maintain going forward. It does recognize rights to witnesses and victims, so our PD side handles that for any witnesses or victims and understands their rights under public record law. It does recognize the redaction of PII, so personal identifying information, and then it does require, or does indicate what records that are confidential by statute. We'll dive into a little bit more about public records requests specifically with the platform. So to add to the confusion, our platform we use is called Just FOIA, even though I told you we don't fall under FOIA. So that adds to some of the confusion when we talk about public records. But we have an obligation under statute to provide records promptly. By doing so, we do have a records officer designated for the town. That is myself, the town clerk. And the way that we comply with this requirement of statute is we use a platform called Just FOIA for the processing of our public records requests. We began using this platform in 2018, and the entire organization uses it now. Our PD partners and Fire EMS came on board. I think PD came on board December of 2022, and Fire EMS in May of 2023. The only department that does not use this form or this platform is our courts department, because they fall under the AOC, the Administrative Office of the Courts. So they have different requirements. So they are not utilizing this program. This program does consolidate the management of requests across multiple departments. It's really intended to be an efficient way to expedite public records requests. It assists us in better understanding what are we seeing, what's the data look like, how many requests are we getting, what's the processing time look like. We're able to really see what it is we're navigating through. But I just wanted to be clear that the law does not require us to use a processing system. That is a decision the town made back in 2018 to make that investment for the town so that we could handle public records requests more efficiently. Prior to that, they were all handled very manually. So that was a decision made back then. This slide is really meant to be as simple as it shows. This is what I believe to be a snapshot on what somebody believes the process looks like when submitting a public records request. First step is the submittal of one. Once received by the town, it is routed for processing. Third step is that it's processed by the department, and then it's released to the requester. But this next slide really shows the complexity involved every single time that we receive a public records request. The first bullet point there, when you submit a records request, law does not require that you submit a request any specific way. You can email one in, come in person, you can use our platform, you can call us for one, or you can submit a subpoena for one. Once that's determined how we get it, we do enter it into our Just FOIA system for processing, so that's a manual process that we have to enter that information if it doesn't already come through that platform. And then once received, and before we can really route, we have to make a number of determinations at that point. Is it commercial? Is it non-commercial? Does it require data, emails, text messages? Any documents that our IT partners have to help us on. Is the request unclear? Many times we do have a request that's broad or a little unclear, and it requires staff time to reach out, sometimes multiple times to a requester to gain that clarity before we even know how to process that request. Is it a town record? Some of our records that we see are actually not records of the town. They may be Maricopa County Assessor's Office or another agency that we have to reach out to that requester and clarify with them. Sometimes we get duplicate requests on different forms, so we have to keep an eye out for that. If it involves multiple departments, that adds to the complexity, and if it involves multiple record types, same, it involves, adds to the complexity as well. And then, is there any type of payment required before we can process? For commercial requests, we do require a $10 payment for commercial requests, and I know our PD partners may require deposits for their records before they can begin processing as well. Once it's routed, there are a level of different needs for departments as they're fulfilling their requests. Documents have to be uploaded by multiple departments, multiple divisions. Sometimes that happens at different times, just depending on backlog and workload. Redaction may be needed. We review all of the records. Us being the town, it's a town-wide initiative to ensure that any redaction must be done. Legal review may be required on some cases, and additional review may be required depending on, case-by-case scenarios that require maybe levels of review on our PD side. And then finally, after all that is said and done, the request is finally released to the requester, and they will have access to their information. We wanted to provide just some examples to kind of put that into perspective. So the example we'll provide is just the request for town email. A request can come in for email. Sometimes it's multiple of the following, right? Multiple date ranges, not just one, multiple search terms, multiple email addresses are involved in a single request. We will route that request to our IT department, and they pull all the records related to those search terms. Those results are then provided to our legal department for an initial review. It does take staff a manual process to review every single email to ensure that they're responsive to what the request is asking. And why that's important is because while we are utilizing a program to pull these emails, these text messages, these programs don't understand context or content. They are taking the words that are being provided into this platform and pulling that information. So it does require a staff member to manually review every single record, every single attachment that is pulled in response to these requests. Redaction must be completed for anything that's confidential or privileged, and then it's sent through another additional final review. Those vary case by case, again, depending on the type of record it is or any required review processes. Then finally, it's released to the requester. And Chris did provide an actual example he had, so I can let him speak to that here.
So, Mayor and Council, this is just one example of one of the types of public records requests that end up, being routed through the attorney's office. The vast majority of requests we don't touch. People making requests for building permits, those are really easy. They get processed through development services. The attorney's office, we don't have a role. We only have a role where there's these broad requests for emails and other documents like that could contain privileged or confidential information, and because of that, we've got to go through each one. So this is an example of an actual request that was made just a few months ago. It's all text and emails to and from two specific council members in the month of August 2024. So IT, what happens is the clerk's office gets this request, whether it was made via email or through just FOIA system. They then reach out to the IT department and says, here are the search terms. And sometimes there's some back and forth. This one's pretty simple. They're not asking for keywords. It's just all emails and text. So IT will then run a search. And then those results, which you see here, there was 3,100 emails, 730 attachments, so 3,800. And that's just emails. That's not pages, right? Some attachments are multi-pages. The time estimate that we give on this is about 40 hours. So that's about what it would take my paralegal to go through each one of these documents and look at each page to make sure, hey, redact what needs to be redacted. Is there attorney-client privilege? And then to get this one request ready to release. This is one of many. We receive lots of like this or very broad search terms. So.
So we wanted to provide another example from our police department. Some of their public records requests may include one or all of the following. So reports, body-worn camera footage, dash cam, building videos, Ring or privately owned videos, photos, 911 audio, dispatch audio. And what's important to note here too is depending on the scenario or the request, it could be one scene or scenario where there's multiple body-worn cameras, multiple dash cams. So although all of these can be requested, sometimes that request will grow substantially depending on that incident specifically, how many people were involved in it, and how many hours of footage are involved. But each of their requests require multiple specialists to work on them. They have specialist 1s and 2s, and we'll talk a little bit more about those in the next couple slides. It can contain hours of footage and audio to review and redact. There's additional levels of review that may be required. Again, that's case by case. It's really hard to say what a standard may be. And then that's already complex, but then if you add any requests for emails or IT-related data, that's handled on the town side. So that does add to the complexity and the volume of information that staff have to review and provide in response to those requests. Again, high level, what that process looks like is once a request is received, this is one for an ongoing police investigation. It may include a police report, body-worn camera, audio, dispatch. It's placed in a queue in order that it's received. Then it's routed for their records team to provide an initial redaction and processing. Then records are routed to assigned case detectives for review of PII, but also case-sensitive information that they feel could possibly jeopardize the ongoing investigation. Then it's sent through redaction and final review, again, case by case, and then ultimately released to the requester. One thing I wanted to make note is PD did provide an example of a very large request that they did regarding body-worn camera. A single request ultimately contained 437 videos. That totaled 4,348 minutes of video and required 144 hours of total processing time for a single request. So just to put in kind of perspective how one request can really add hours and hours of footage and audio just depending on the incident in question. This information is just kind of what we're seeing. We talk a lot about how much we're processing, how many requests we're getting. We do know that in some cases we do have records requests in the queue or maybe a backlog of requests, but I wanted to show this to show that while we are getting a substantial number of requests, we are actually completing a great number of requests as well at any given time. This shows the data for 2023, 24, and then 2025 to date. So in 2023, while we completed 24,373 requests, we received 25,492. So we've kind of seen that be the standard across the board, that while we are trying to keep up with the demand, we are still getting a higher volume of requests than we're able to keep up with in most cases. A lot of times I feel that's due to the volume of them, the complexity, just the details that are required and the manual staff time required in each of those requests that are coming through us. And then this next slide is more specific how each of these departments are processing. These are completed requests across the organization. These 6 general names are the names of our forms within our platform. So PD, as you can see, have by far the highest number of requests coming in. And the last arrow there, 2025 to date, those numbers are still small, of course, at this time, but we are watching them and we believe they're still gonna be above the last year in terms of the number of requests that we're being able to be completed across the organization. Going into a little bit about staffing and support, we do have some dedicated positions in some of our departments. We have one in our town attorney's office. We have one in our, oh, sorry, I skipped a slide. Let's talk first about program costs. We do pay ongoing costs to use the JustFOIA platform. Currently, it is around $20,000. However, due to some necessary updates of the program and to support the various needs that we're seeing across our department, specifically our public safety partners, we are going through an upgrade of the platform, and ongoing costs will be around $32,000 in FY 2026, and those do also come with a 5% annual increase every year as well. And then talking about staffing and support costs, we do have some dedicated positions And when I say dedicated, those positions were created specifically to kind of handle the workload of public records requests and records. We have one in our town attorney's office, it's a paralegal, one in the clerk's office. We do have additional positions that I just wanted to make mention of because those positions weren't initially created for public records, but it's my understanding that they completely absorb them for their various departments. So one in our fire department and one in our building department. And then, of course, we have dedicated positions in our Gilbert Police Department. They have 1 records manager, 4 record shift supervisors, 21 record specialists. Of the 21 specialists, 16 are considered specialist ones. So they do not actually currently handle any of the digital media review and redaction. So 5 specialist 2s are handling the majority of that information. So I wanted to provide this because although we're able to understand staffing costs for these dedicated positions for public records, there's a huge organizational impact involved. It's a responsibility for everybody to be able to assist with fulfillment of public records, whether it's compiling the data, reviewing the data, redacting, coordinating multiple department requests. That is a substantial number that is very difficult to understand. We don't currently track staff time for public records requests. It's a requirement that we must comply with. So while we are able to provide some understanding on what we know, there are some other impacts that we don't have the information on at this time. And I know, Chris, you had some information on some costs for your team specifically.
Yeah, so for my team, again, our role in the records process is when we're looking at items that need redaction or there's potential confidentiality or best interest. So I've got one dedicated paralegal. She was, it's a new position that was created a couple of years ago. Before that, we just handled it without the full-time employee, but we were getting so many, it seems like so many more requests of these broad requests that required a detailed review. We ended up hiring a new paralegal. This is her job, full-time, and then an estimate with just our other staff, and then attorney time. About 10% probably of the attorney time is spent looking at and checking her work on the redactions. So as far as numbers-wise in the attorney's office, and this is just our role, with one full-time employee and some part-time work, we're looking at we spend probably $300,000 to $350,000 a year in attorney work, including the paralegals, in fulfilling the town's obligation to respond to records requests and make sure that they're fully looked at before they get released.
For the clerk side, we do also have a full-time position, and we do utilize our administrative assistant as well to support that effort. And for our PD partners, they do have those full-time staff members as well. So we do have projections on how much they're spending on personnel cost. They're about $2.1 million in personnel costs for FY 2025, but they do have a larger group dedicated to public records. So these are the known costs for public records, and while we can speak to those, this type of work is larger than that. The true cost is something that's very difficult to put in perspective, just again, because it reaches every single employee of the town, and it's a requirement and a responsibility of all. Are there any questions on staffing before we move on? Go ahead, Councilmember Buckland.
Thank you. In regard to the video redactions in PD, are we doing general blurs or are we doing precision redactions on each of those?
Good afternoon, Mayor and Council. Lorenzo Turia, Sergeant over our Public Affairs Office. To answer your question, Councilmember Buckland, it is a general blur.
All right, we'll move on, but we can always go back to any slide if you have additional questions. This slide just shows our fee schedules that are approved. We just wanted to make note, too, that all fees collected, whether it's from the PD side or the town side, do report, go into the town's general fund, so they don't go to any department specific, not the clerk's office, not PD. They are used for general fund spending. And then for the town side, we do have some limitations on what we can charge for non-commercial requests. As you can see here, we can charge to reproduce a copy or for mailing, but we do not charge, and we're not authorized to charge for electronic records. That adds to kind of the issue that we're seeing is the amount of staff time it's requiring to produce these records. We aren't able to other than the charge to make a copy, which nobody is asking for hard copies anymore, or to mail out anything non-commercial related. Those are the only thing we're authorized to charge for. And then last slide is just limitations and restrictions that we see with public records law. Statute establishes what can and can't be charged. There's not a lot of wiggle room in that. It doesn't really expand to any level of that we can really modify our fee schedule or structure on. Requests are not required to be written. So again, there's no mechanism for anyone to submit a request. They can come at us at any time in any way, and we must provide them the requested information. Requesters are not required to disclose their identities. There's nothing in statute that requires them to provide their name or address. All they're required to provide is an email address if they want electronic copies. Otherwise, they can come in person and pay for hard copies if they wish to do so. We do have our promptly furnished concerns. So while statute requires that we must promptly furnish records, we do have to look at some of our agency resources, what we're able to do, how quickly we're able to do them, the nature of the request, like we talked about how broad some of them may be and how complex some of them may be, the content of the records, does it require extra review, redaction, and then location of our records. If any of our records are off-site or saved at a historical facility, we have to look at that as well, and how can we obtain those records if they're not digitally available. Requesters must determine if the request is commercial or non-commercial. However, they don't have to disclose what they intend to do with the records or why they are requesting them unless it's a commercial request. So I wanted to point that out and just really end this this PowerPoint while saying, while we strive to be as efficient as possible, processing of public records requests is a very manual process. It does require a very real human element to understand context, content, and really do a manual process of redaction and review. We are always trying to balance the responsibility to provide records as promptly as possible, but also protect the community and redact what needs to be redacted, not disclose anything that's private or confidential, or anything that may jeopardize any ongoing cases. So it is really a balance that we're all trying to be efficient and maximize, but we're open to any questions if you have them, or if Chris has anything he wants to add.
Thank you, Mayor. Oh, my light's on, I know, I have a question.
Yeah,
I have a question. Oh, okay.
go ahead.
All right, thank you, you got that straightened out. Well, first of all, I had no idea that Councilmember Torgerson and I had 3,100 emails and 784 attachments in August of 2024. But I have to ask, I mean, that costs $2,000, estimated $2,000. Any attempt to go back to the person or persons to say that's too broad? We can't give you every email, every attachment, every text message. Is there anything that we can say, we need specifics of what you want to save taxpayers $2,000?
So Councilmember Bongiovanni, that's a great question. We do go back. I know often in the clerk's office, the records specialist will, when there's broad requests, will go back and try to work with that requester to try to narrow the request. Sometimes it's we get the request, she'll go to IT, they'll do a data pool, and they'll see, oh, there's 20,000 records. They'll go back to the requester and say, hey, can you narrow this? What are you looking for exactly? Trying to find terms like that. In this type of scenario where there's not terms being searched, it's just, I want all these emails, the answer is we can and often do, but if they want those records, then we provide those records. The exception is the best interest. So if they're asking for every email from the council for the past year, and it comes back at, I would assume, hundreds and hundreds of thousands of records, we would push back and say, hey, in the town's best interest, we cannot dedicate the number of hours it would take to get through that request, however long it would take, 6 or 8 months for one request, because doing so, we're not going to be responding to any other records requests. So when there are requests that are super broad, we do go back and we try to get them to narrow it, and ultimately there have been times where the requests have been so broad and they're not willing to narrow it that we will push back and just say, hey, in the town's best interest, we're not going to provide it. And in doing so, we have to articulate why. We have to show an estimate of amount of time it would take, because that's what the court's going to require. We can't just say it's going to take too long. So we go through that analysis every time that we're going to push back and say, this request is just too broad. We're not going to go through 100,000 documents. Emails, which is multiple pages of documents. And so that's how we deal with these types of requests.
Wouldn't cost be to the best interest of the town?
No, it would not be, not under the statute. Now, what would be is the amount of hours it would take. And so what the courts have said is, they don't look at the cost, the courts don't care about the cost. But if we estimate that's going to take four employees working full-time for 6 months, and in doing so, it's going to take them away from other job duties, that's what the courts will look like. It's more the amount of time versus the cost.
Okay, so in this case, estimated cost was $2,000 to the taxpayers. I would hope in the future we would, if we're able to, is what I'm asking you, Chris, are we able to go back and say, no, you can't have every email. We need to know specifically what you're looking for to lower that cost and lower that time?
We do that a lot. We do that often, Councilmember Bongiovanni. We will go back and try to get them to narrow. And ultimately, if they don't want to narrow the request, they don't have to. And then then the analysis that we'll have to make with the clerk's office is this request so broad, or are the documents, that the responsive documents, this case was what, 3,000, which is relatively small compared to a lot of what we've seen. 40 hours of staff time to review one request is a lot, but compared to some of the other requests we've gotten, it's not that big. So, and some of not all the requests are the same, because sometimes you'll get a request and it may have a lot of documents, and then once the paralegal gets into it, she can see there's a ton of duplicates and can pull out those duplicates pretty quickly and narrow that request. Other times, 3,000 documents may take more than 40 hours because they're all confidential. They all have PII where you're going to have to redact a whole bunch, and that's very time intensive.
Yes, I wanted to go back to the multiple thing there for a second, but in order to request a FOIA, they have to submit, well, one of the ways you mentioned was submit an email. What would stop someone from using multiple emails to make frequent and wasteful requests?
Nothing. The people don't have to identify who they are. They can create an email just to create a request, and we cannot inquire who they are or why they want it. We just get a request, and that requester could be a Gilbert resident, and it could be someone that lives in a different country. The law doesn't care. We just have to respond.
But if it wasn't wasteful, why would someone use multiple emails?
It's a great question. I'm not sure if they're trying to hide their identity for some reason, but I'm not sure.
And this might be for Chiavelli. Are there any individual or individuals that you feel are using multiple emails based on the request they're asking?
Councilmember Bongiovanni, I'd have to review the request. We get such a high volume of requests, it's hard to really see the full picture of what we're seeing. Once we get them, we route them outside of the clerk's office, so we only see them once they come in or once they're in our queue for processing. But as Chris spoke to, it would be easy for somebody to utilize multiple email addresses since we don't require anything else other than an email address to provide their records request.
Thank you. And Chris, what is the litmus test for abuse of the system and frequency and cost? And I know, I preface this with, I know other states have laws about people who abuse the FOIA system. What is our litmus test to say, hey, enough is enough?
The law doesn't provide one. The law requires that we promptly furnish records, subject to the exceptions for confidentiality, privacy, and the best interests. So if someone wants to submit a lot of requests under maybe different names, we have to respond to those requests. And Arizona law is not set up to point to anyone that's maybe potentially abusing the system to try to overwhelm the town or its resources. We just have to respond to each individual request.
Okay, thank you.
Actually, we had spoken about some of our frequent flyers, so I think a little clarity on that would be great, is that there are some people that are abusing the system using multiple emails. We've discussed this, you and I, and through their references back and forth between different requests from one email to the other, we've got some people doing massive abuse of the system.
Councilmember Torgerson, we do have requests that are very similar. So I think it's easy to maybe assume that either there's a specific topic going on or assume it's the same person. But without having that information in front of me, I couldn't tell you as of right now what requests we're seeing. Another person from my team routes them, but I could see where at one point we do have some very similar requests where we do believe it could possibly be the same person asking for the same information. But again, utilizing other email addresses, that would really just be an assumption that we wouldn't be able to confirm.
I would say if you put a name down and then your other email has the same name but with a number after it, and then the next one has a different number, you're pretty much the same person. You know, and the written requests are written the same way, et cetera. My concern here is that Gilbert is the highest record request municipality in the country. Chicago doesn't stand in our shadow. So how do we get this from upwards of $3 million a year from what you guys are telling me? I mean, millions of dollars. And people are using it as a weapon, as lawfare. Is there anything that we can do, propose, try to work with the state to lessen, because everybody needs their information. I mean, the press should have the information. People that feel they've been abused by, you know, police or something went wrong, I got it. But when it's not genuine, where can we get to a point of 40 hours on one? 40 hours. That's a full time. That's one. That's not a big one.
Councilmember Torkelson, I completely agree. We are very limited in what we're able to do with the way statutes currently written. It would require changes at the state level for us to make any substantial changes to our process.
And I'm still going to say that our state legislatures don't have the courage to move forward with that. It's been the general discussion. But maybe we need to tone down what we consider best interests. I mean, at a certain point, is a fishing expedition worth $2,000, and especially when that fishing expedition is going on 52 weeks a year. I mean, it's going on all the time. We know it is. We have to find some way, or do we as a town, sit there and get on our knees and grovel to the state? Please give us some relief for that. We're paying more than Chicago, and it's more than just a line item of our costs. I'd rather have the citizens have $3 million back, anything.
No, I understand what you're saying, Councilmember Torkelson, and agree with Chiavelli that it would take a legislative change to tweak some of these statutes. Personally, I don't think it would take much. If you require a requester to have a little bit of skin in the game, you have to, don't even have to charge per hour, but putting something, rather than make a broad request of $5, $10 per request, something like that, even small, I think would help in that scenario. But when it comes to the best interest argument, we can't look from a cumulative standpoint. We can't say it's in our best interest to not respond to this request because we've gotten 14 others or there's 30 others ahead of us. We have to make that argument and that claim on a case-by-case basis, because a court's not going to care that we've been inundated with super broad requests. They're only going to care about the one case that's in front of them. And if we're saying best interest, they're going to be looking at the specific facts of that case or that request and nothing else.
Well, let's say in my case, we talked about this. What is the cost of just opening up every single email of mine, every single text, everything, and just having it dumped into a public records file? If somebody wants it, we already did it. It's got to cost less than letting these guys monkey around. Is that something we can do?
It may, so we'd have to look at, in your scenario, it would be all your emails you would just make public and maybe it's available on the website, would be look at the staff time it takes, and it would probably vary by the amount of emails you get. Before we open it up for the world to see, we'd have to just vet it on a regular basis to make sure there's no attorney-client privilege, make sure there's nothing confidential before we do so. But we could look at that based on the average amount of emails that you get in a given month, and then kind of weigh that versus the records requests that we're getting versus the staff time it would take to get those emails where they could be just placed publicly for the world to see.
Well, I thought you were looking at the cost of just opening up my emails.
We are. I don't have a number yet because
Yeah, 'cause let it be said, I have no problem, open up every email, every phone call, every text. But I want the abuse of the tax dollar to stop, because these few people are costing us hundreds and hundreds of thousands of dollars. And it's not just me, it's everybody. But if it can be done for a reasonable number and just open everything up, I have nothing to hide. And I'm sure nobody here has anything to hide. I want to stop the abuse. And if that's what it takes, I'd much rather pay for it and just have it in a box for everybody to look at whenever they want, than all of a sudden find out that you're getting inundated with something, whether it's me or whoever. And the cost of it's just unbelievable. So if we could really drill down and look at maybe just opening up everything, it'd be great.
We'll look at that.
I know that the Freedom of Information Act is something that's important, and it's good, because it does add a certain amount of transparency to everything the government does. But as two council members have pointed out, it's easy to abuse it now, especially when we're handcuffed by everything that Chevelle outlined on things we can't do. We're handcuffed. And it might be worth at least talking to our legislators to see how they feel about it. I know that FOIA is an important thing for them too, but I'd like to get an understanding with them that we do lead the nation, and this is being abused by citizens that are having would have a hard time proving the benefit of what they're finding. And it may be worth that discussion. Any other? Go ahead.
Okay, I'll be quick. Can you clarify something? I'm not sure if I heard it correct before. And I thought you said that you can ask them what they plan to do with the information. And there was another question ahead of that as well.
Yes, Vice Mayor Buckley, you can only do that if they are determining they are going to use it for a commercial purpose.
For commercial,
Yeah, if it's non-commercial, which is the majority of our requests, we can't ask them that. If it's for a commercial purpose, that means that they plan to sell the information or have some type of monetary gain. And at that point, we would be able to recoup a portion of it if we chose to do so.
Okay, thank you.
Thank you, Chevelle and Chris. Have you talked to peer agencies to determine if Gilbert is on par with the responsiveness and processing of these requests? I know that we may have more volume of requests, but how would you say that we benchmark against other agencies in Arizona in terms of responding? Because from what I'm hearing, we are trying to be as responsive as possible, and we're very transparent, which is fantastic. However, we're also seeing that it's a major burden. So that's my first question.
Yes, Councilmember Kaprowski, we have reached out to partnering cities. It has not been recent, so I think it's probably a good time to reach out and just ensure that what we're seeing, others may be seeing, and how they're handling similar situations. And we also, at one point, reached out regarding our fee schedule to see if we were comparable to others, and at that time we were. But I think it's a good opportunity to do that again and bring back some information.
Okay. And my other question is, what are the consequences if we are not able to provide them information in terms of, like, let's say that our paralegal isn't available for a month or two, and so a response gets delayed. Are there consequences for the response from the town if it takes too long to respond?
So as Chevelle had mentioned a couple of times, the town's required to respond promptly. And there's no time frame that the courts have said. If we're challenged and we get a lawsuit, the court's going to look at everything to see if this was a prompt response, including our available resources, the amount of records requests that preceded this. So in that scenario, Councilmember Kaprowski, if the town or someone, a requester does not feel like the town is responding promptly, we hear from that on occasion, you know, we try to give updates, but ultimately if they feel like we're not getting them the records in the timeframe that they request or that they expect, they can file a lawsuit, and that's where they'll go. They'll file the lawsuit and try to argue in front of the judge that the town has not been prompt in its obligations. So, and the risk there to the town is on our records, on our public records lawsuit, is that we would be liable for their attorney's fees. If the requester files suit and wins, then we would have to pay our attorney's fees as well as the plaintiff's attorney's fees.
Thank you.
Let's wrap this up as soon as we can. We've got a lobby full of kids waiting to come in.
I'll be real quick.
Councilmember?
On the, thank you, Mayor. On the fee structure, is that something dictated by statute, or do we establish that ourselves within certain parameters?
Councilmember Lyons, these are fees that were approved by the town council. Some are authorized by statute. I think body worn camera was a change that happened in legislation that allowed that to be charged. But these fee schedules in general were approved by resolution of the town council.
So we could revisit that if we needed to, Chris, is that correct?
Yes, we could revisit that. Some statutes are very clear, like the body-worn camera one, which is a newer one, a new statute for the last couple of years. It capped the amount that you could charge, that a city could charge. But I think a lot of, or maybe the bulk, and Chevelle can jump in, the records request where they're asking for emails and electronic records, we can't charge at all. So while you look at this, the copies, those are dealing with, we're actually making physical copies. Everything today is electronic, and I think part of the frustration or part of the difficulty with the statutes is they have not been updated for the most part since the world turned electronic. So back in the day when cities could charge for paper copies, the statutes haven't been updated to recognize that everyone deals electronically. So that's why we can't charge for the electronic side of things, because the statutes haven't been updated.
Thank you. So let me talk about my frustration is that when, you know, Gilbert is a very prosperous town, and we can only afford $10,000 to help seniors and people on fixed income pay their water bill. But yet we can spend $400,000, $500,000 on wasteful FOIAs that we know are just being submitted as harassment. With that said, is there any degree of privacy for those asking for a FOIA?
You're saying the requesters?
The requester.
No, the requests themselves are subject to public records.
So I can FOIA a list of every email and how many requests they have made to the town of Gilbert in the past year.
And we do get those on occasion. Go ahead if you want to speak to that.
Yes, Councilmember Giovanni, we do get requests for a list of all requests that have been made, so that is something that we're familiar with providing.
Okay, so I will plan on doing that. Thank you.
One quick question. You said it hadn't been updated. Since we do so many things electronic, if it's not been updated, can this be put on a thumb drive and left at the front desk, and we don't deliver it electronically? You have to come and pick it up? Is there anything that prevents us from doing that?
Councilmember Torgerson, we do charge for thumb drives. That is part of a fee on the fee schedule. But I think some of these requesters, they don't identify their location either, so they might not live in Gilbert or nearby to be able to swing by and pick something up. But also the benefit of having a platform like just FOIA is the efficiency in getting a request out to the requester as soon as we're able to do so electronically.
Right, but I'm trying to bring some responsibility from the requester that has to show their face in here to pick it up.
If I jump in, and please. I think, Councilmember Torgerson, what you're saying is if the town were to change maybe its procedures and say, we're not providing things electronically, we'll provide them in electronic format, but you've got to come down and pick it up. We'll burn it on a disk or do it on a thumb drive. I don't know of anything that prevents us. We provide them in electronic form, but just through a physical media versus sending out a link on just FOIA or something like that. I don't think the law would prevent the town changing its procedures, but Chevelle, please.
That's the answer.
That's correct. Nothing in law would prevent that. It would just be a process change. All of our records are uploaded to the system, redacted within the system, reviewed within the system. Again, that's one of the beauty of, that's one of the benefits of the program, honestly. So to do so, we'd have to extract all the records from the platform, which would create multiple records. So there's just some considerations before we would make a decision to move in that direction.
Yeah, and I've done that when I've requested that, so pulling that onto a thumb drive is nothing. That takes no effort at all. So that a procedure may eliminate millions of dollars of waste. A simple procedure change.
Let's wrap this up. Are you okay on direction we're going here?
The direction I received, and Chris can jump in, is just to do more research. We'll look into opportunities, as Councilmember Torgerson said. We'll look at partnering cities to see what they're seeing, what they're dealing with, some of their records, some fees. Go ahead, Councilmember.
I'd like to see some possible law changes on the state level, just maybe some language, just some of your thoughts on that too, Chris.
We'll work with our InterGov team as well on that.
Yeah, right. Open a dialogue with the state legislature.
Absolutely.
That works all the time.
That works all the time.
Well, thank you. We
Thank-
appreciate the
thank you.
feedback.
Thank you. Okay, we'll adjourn this study session and herd the cats into the chambers, and we'll start in a couple of minutes.